Good evening, comrades. Yesterday, we vehemently looked at the laws relating to individual insolvency. So today, we are going to analyze the laws relating to corporate insolvency so that we are able to understand the difference between corporate insolvency and then individual insolvency. Okay, these are basically simple things that we can understand and deal with in the shortest period of time. Okay. So let's get our act, but make sure you have the amendment. So what do we understand by corporate insolvency? Just know that when you are dealing with insolvency, whether corporate, whether individual, the starting point is so insolvency situations. Always, whether you like it or not, there should exist insolvency situations, because there is no way you can commence insolvency proceedings without, okay, there is no way you can commence insolvency proceedings without insolvency situations, because there should exist insolvency situations first, then we proceed and go for insolvency proceedings. So in whatever you are doing, make sure you understand what amounts to insolvency situations. It's the starting point, it's the gist of everything. So now let's look at the law. So let's go to section section 56 of the Insolvency Act. It says corporate insolvency. It says that modes of, so what you should understand that what we call corporate insolvency is also known as liquidation. Okay, so when you look at section 57, it gives you the different modes of liquidation. The one, it can be by court, it can be voluntary, or subject to supervision. So depending on the factors surrounding you, you will be able to choose the most appropriate one to you. Okay? Are we together? So now, let's go on. So, As I told you yesterday that the insolvency laws, they hate what we call insolvency proceedings. So if the insolvency laws hate insolvency proceedings, okay, that means before we go for insolvency proceedings, there are certain things that can protect us first, okay? So before you say you are choosing a mode under 57, what things you as a lawyer who is protecting your client from being subjected to insolvency proceedings, what things are you supposed to do? Okay, so let's go to what we call interim remedies in circumstances of corporate insolvency. So these remedies are here to protect the company from being subjected to insolvency proceedings. Okay, so under this, we have remedies under the Companies Act and then remedies under the Insolvency Act. So you should differentiate. Okay, under what circumstances do we consider this, and under what circumstances do we consider the other? Okay, we go on with those under the Insolvency Act. The first one is what we call provisional administration. Provisional administration. Provisional administration. Was section 138 amended? Check your amendments, because 90% of these sections we are reading were amended. Okay. Okay, so now let's go to section 138. So what the things you should note that there is a difference between administration and provisional administration. Okay. The way we saw a provisional supervisor and a supervisor, there is a difference. Okay. So here we are looking at what we call a provisional administration. So we are looking at section 139 now. It says that a provisional administrator of a company shall be appointed by a special resolution of a board and a notice in writing under this part on the date of the interim protective order. So now, when you read this, it mentions about the interim protective order somewhere. Okay, so what does this mean? Unlike the other side, where you first go for provisional, you first get an interim order. Here the things are at the same time. You get it? We also have the interim protective order here. But the other side, you do what we call a provisional arrangement. Okay? The proposed arrangement. So the essence, for you to be able to go for that, you should ensure that you are intending to make. But when you read this, it says a provisional administrator of a company shall be appointed by a special resolution okay, shall be appointed by a special resolution in writing under this part on the date of the interim protective order. Okay, so that implies that the day you get the interim protective order is the day you appoint a provisional administrator. Okay, so they work hand in hand. Okay, then subsection 2, a notice appointing a provisional administrator shall include a certificate signed by the appointer satisfying that at the time of the appointment, there is a reason to believe that the company is or will be able to pay the debts within the meaning of section 3. Okay, so what does this imply? The same thing I told you, that everything starts with inability to pay debts. So you should prove, before you appoint a provisional administrator, you should first prove that you are unable to pay debts somehow, somewhere. But before we do anything, do you understand just the understanding of administration? Or I'm explaining just magic? The problems that an individual like her face, they are not inclusive of administration. You get it? But the problems that bring financial issues to the company include poor management, which you know as administration. So for the company to gain sanity, you should appoint someone to come and deal with the management of the company. That's why we have that tremor of administration, because the biggest problem of institutions is management. Okay, so we proceed. Then subsection 3 says that before a company appoints a provisional administrator under this section, the company must, by special resolution, agree that the company needs to make a settlement with its creditors. So together. So what does this mean? The essence of administration is to make sure that you find means of dealing with your creditors. Okay? So then the company shall, after agreeing to make a settlement with its creditors, petition court for the interim protective order. A provisional administrator may not be appointed under subsection 1 after the company has gone into liquidation. So you see, once the company crosses to liquidation, we don't appoint a provisional. You get it? So now, the question is, what is the procedure of appointing a provisional administrator? Okay? What is the procedure of appointing a provisional administrator? What's the procedure? One, issuance of a notice calling for a board meeting. Then two, making an agreement that there is a need to make a settlement. Making an agreement that there is a need to make a settlement with our creditors. Then petitioning court for the interim protective order. Petitioning court for the interim protective order. Then appointment of a provisional administrator. Because the day you petition court, it's the day you appoint a provisional. Okay? So remember, down there in brackets put by way of a resolution. Okay? Because you do that by special resolution. Okay? We'll go on. Now, the provisional administrator has been appointed. What are the duties of this fella? One, investigating the affairs of the company. Another one. After making investigations. Then also to make a report in regards to the affairs of the company. Then another one, to call for the creditors meeting. To call for the creditors meeting. Okay, so now You will also look at the commencement of this person when he commences his duties. Okay. So now, what are the effects of provision administration? The things are the same, exactly. Nothing changes, just the names. So for they are the same as those ones we looked at for the supervisor, but under these, you look at section 143. So now, then what is the lifespan of provision administration? There is a question you guys are going to see. It is on insolvency. I know you'll see it, but 90% of you will fail to attempt it. It is on insolvency, but it is under administration. The company was under administration, and the creditors did one contrary to the administration did. We shall get there, you'll see. Okay? So now, someone with amendment, look at 145, it was amended. Okay? 145 was amended. It says that Section 145 of the Principal Act is amended after subsection 2 by substituting the word 10, the word 15. So what does that mean? In the old act, they said that a provision administration shall terminate when the period specified in the interim order lapses, and the period shall not be more than 30 days. Then the administration deed is executed as section 148, or the provisional liquidator gives a notice required under 151. Then, because the amendment talks about subsection 2. So you go to subsection 2. It says that subject to subsection 3, the provisional administrator shall call the creditors meeting to end the provisional administration under section 148, not more than 10. So this 10 was amended to 15 working days. So what does that mean? Okay. The circumstances under which provisional administration ceases: 1, okay, by lapse of time, because an order has a lifespan of 30 days. Okay, it has a lifespan of 30 days. Then after that, if not that deed, remember, once you execute the administration deed, obviously this comes to an end. Okay. Okay. Then another one, upon coach. Okay. So now, the presumption of administration protected. Remember, under provision administration, we get the interim protective order. So that means we have discussed 2 interim remedies at the same time. Have you noticed that? We have provision administration and then the interim protective order, because they are made the same day as when you look at that act. They are made the same day. So you have two remedies. So that means we've looked at the interim protective order and then, but now the question, because we looked at provisional administration, it is by way of a resolution. But the question is, how do we get the interim protective order? Does the law provide? How do we get that? Because the rest we have dealt with them. Okay? These things change a little bit. Okay? So how do we get the interim protective order? Okay, let's go to regulation 135. Now, have you know, or did you read the civil procedure rules? How do we deal with company matters? By way of, so it can't be notice of motion. This is the company council. Okay, so let's go to rule 135, okay, of the insolvency regulations. It says, petition for interim protective order. A company which by special resolution of the board agrees to make a settlement with its creditors and appoints a provisional administrator under section 139 shall within 14 working days after the resolution petition court for an interim protective order. The petition shall be in Form 27 of Schedule 1. So you open behind. Okay, don't draft the notes of motion in the company matters. Those are things that are going to come in your IA. Because it was the exam, it was the very IA for your colleagues. We shall read here, you will see that it was another problem. Okay, it was the very IA. People read the amendments when it does not even apply anyway. Okay. Yes, it is Form 27, the petition. Okay. So the petition shall be verified. It's not supported by an affidavit. It is a verified one. Okay. So now we are under provisional administration. We also have our interim protective order. We are at liberty to do all the nonsense we want. Okay, but what if it expires? So what you should note, whenever you have the remedy, you have a right to extend that. Okay, because after you've gotten the interim protective order, okay, and then the provisional administrator, the next step will be calling for the creditors meeting. The essence of the creditors meeting is to agree so that you enter into what we call administration. So if the creditors don't agree with your proposal, you make an application for extension of the interim protective order. You get it? Because you see the IAS you guys are doing this time around. You rush, you read it, you say as if it is very simple. But the moment you start writing, so when you start seeing stars. That's why they told you that insolvency is not for the weak-hearted. It's hard, but it's simple. So far, I've not seen anything challenging. Not so? So now, we are under provisional administration. So now let's go to what we call convening of the creditors meeting. Section 146 as amended. It was amended. Okay. Okay. It says okay. No, we are going to look at 148. It wasn't amended, I think. 148 was not amended. So now, once we appoint the provisional administrator, remember one of the duties of the provisional administrator is to come up to make investigations on the affairs of the company. So after you've dealt with the provisional administrator, so you'll end up making what we call a proposal, so that you present this proposal to the creditors in the creditors meeting. So the essence of the creditors meeting is to ensure that you convince the creditors so that they adopt the proposal and they appoint an administrator. You get it? So this proposal ceases to be a proposal and it becomes an administration deed if it has been agreed upon in the creditors meeting. So the ultimate duty of the provisional administrator to investigate and then invite the creditors for the creditors meeting. So let's go to 148. It says that the provisional administrator, here the wording. So it is only the provisional administrator who calls for the creditors meeting. Okay? It says that the provisional administrator shall be the chairperson of the creditors meeting to consider his or her proposal, and subject to this section, the meeting shall be conducted in accordance with the third schedule. Okay, we can't go much in the conducting of this meeting, but we share that the essence is basically to consider the proposal. Okay, so now when you go to subsection 2, says that a creditors meeting under this section may be adjourned, but shall not be adjourned to a date that is more than 7 days after the first day on which the meeting was held, even if a resolution under subsection 3 has not been passed. Okay, so now what we need in the creditors meeting is under subsection 3. The creditors may resolve A, that the company execute an administration deed as specified in the resolution. You get it? So what does this mean? Once you present to them the proposal and they adopt the proposal, it will change from the administration proposal to what we call the administration deed. And once they sign the deed like this, that's the end of provisional administration. Okay, so then another one, that provisional administration ends. So you get it, there's a act to come out. Okay, then that the company be liquidated. So what does this imply? Once these guys don't agree with the proposal, they can subject you to liquidation anytime. So the creditors have a lot of powers than what you think. Okay, ask Craney Bank, Greenland Bank, it is. Okay, so now, what are the contents of the administration deed? You go to section 140, 9 says the administration deed shall specify one, the proposed administrator. Okay. Then the property of the company available to pay the creditors, the nature and duration of the moratorium period, etc. etc. Okay. Under 149. So whatever is listed under section 149, they are the contents of the administration deed. These things are very simple. Okay. Then when you go to 150, it talks about execution of the administration deed. It says an administration deed shall be executed by the company and the proposed administrator. Okay. So now, once you execute the administration deed, it is binding. It is binding all the parties to it. Okay. So what you should note, once the administrator and the administration deed replaces all the management of the company. So the director ceases to have powers, the auditors, the secretary, they are all answerable to who? The administrator. Now, go look for that paper. I've told you it is in the question bank. Okay, it has facts where the company was under administration. Okay, the administration did specify the particular period of time, but the administrator they appointed was known as Miss Kwatampola. So these guys argued that Miss Kwatampola was too slow. Okay, was too slow for them to proceed with her. So there's one, the landlord was demanding for rent and he was intending to institute legal proceedings against the company. Okay. Then these guys wanted to terminate the contract of Miss Kwatampola as an administrator. The creditors, the directors refused Miss Kwatampola to access any document in the company. Secretaries never availed her with any information. So Miss Kwatampola was before you. Look for that paper. Okay, it is there. I've ever read it. Okay. So now, after we sign, we execute the administration deed under 150, then the company has gone into what we call administration. Okay, so administration commences upon execution of the administration deed. So now ask yourself, what are the powers of this person? Okay, the administrator. Okay, when you go to section 162, says administration. Okay, and then commencement of administration. Under 162, they may drop him or her. They have the discretion. As for you had the girlfriend at high school, but after graduating, that's what is seeing you. Okay. Yes. Yes, must. Hey. Okay, so let's go to 162. Says that it was amended as well. Okay, It was amended. It says that administration commences with the execution of the administration deed by the company in the general meeting. Once you guys sign the administration deed like this, it terminates provisional administration and then you enter into administration. So now, what happens where the company enters into administration? Okay, so the first thing is issuance of the notice of administration under section 163. Okay, but 162 was amended where I say that the administrator shall within 5 working days from the date of execution of the administration deed under subsection 1 file the administration deed in court. Why, when you look at this, okay, the amendment, it is very emphatic. Why? Once you because you are appointed, okay, when we endorse the administration deeds, okay, but remember these are company matters. We need the endorsement of courts. So once you are appointed, within 5 working days, you submit the administration deed to court, and then court endorses it, and it becomes the administration order. Okay, so that you are protected by court. Okay, so now after court has made the administration order, then we look at what we call effects of administration. What benefits does the company enjoy when it is under administration? The same benefits we saw, they are the same, they don't change. Okay, they don't change. You go to section 164, which was, yes, thanks. Yes. Mm. No, yes. In administration, eh? Mm. Remember, council, you made an application for the interim protective order. Okay, so by virtue of that, the essence of the interim protective order, yes, no, you just write, you attach the administration deed, and then court endorses it with a court seal, then it becomes a court order. Okay. Okay. So now we are under administration. You have the administration order. We go to the effects. The very effects we saw, they don't change. Let's go to the amendment of section 164. But most interested in subsection 2, which says, because 1, let me tell you the technique. Section 164 as amended, it says that the administration deed shall bind 1, the company, okay? The company directors and secretaries, shareholders, administrators, and then the creditors. How does this operate? Once we enter into administration, the director should not speak again, because remember that we are the administrators. You get it? So now the administrator replaces who? The director. Who appoints the secretary? That means once the director is replaced, the secretary is automatically answerable to who? Who appoints auditors? Shareholders. Okay. If 164 says that the administration deed is binding to shareholders, that means the administrator replaces the share somehow, somewhere in giving of powers. Not so? So that means the auditors, whatever they should be giving to the shareholders, now they should give it to the administrator. So they can give you facts where everything is upside down, like that question I've told you to look for. Okay, and they give you that IM. So for you come out and I'm going to draft the petition, they will fill you. You get there, no petition, nothing. Even they have given the administration deed. When it is endorsed, I ask yourself, and you say, what are the necessary documents? 40 marks. Say, oh. Now these 40 marks were from where? So I draft a letter requesting for the record of proceedings. Okay, so you should be keen with this. So now, we are interested in subsection 2 of section 164. It says that subject to subsection 3, the person bound by the deed shall not, 1, make an application for liquidation of the company or proceed with any application. So that means the creditors, they cannot in any way go for liquidation, whether you like it or not. They should just sit down and be humble. Okay, then another one, except with leave of court and in accordance with the terms of the court, may impose 1, take steps to enforce any charge over any of the assets of the company. So even if you have any asset of the company, you can't enforce a charge. Okay, then another one, you can't commence or continue execution proceedings or other legal proceedings or levy distress against the company. However, you see, when we are growing, you could disturb your elder sister or brother. And once I get hold of you, I'm going to beat you, even you call your mom. So because you know this person did something and you promise not to report. So what you do when your mother comes back, you sit near your mother. You start doing like this. What? You say, Kamugambe. So you get close to mama as if you're telling her that, you know what? Must you call James here and you say this person is protected. You get it, So that means even if you want to beat him, this person has your separate. You have to just what? So every time you mess up, should I tell mom? Okay, will you give me money at school? Yes. So you end up giving your pocket money because someone is keeping your separate. So this person will take it that it's the company which is under administration. The landlord needs rent, the guys don't pay. You can't go to court. You have to just look at them. Now the company is this baby who saw you with James. So every time you say, it's okay. Okay? So you keep on giving out your eats for no good reason. The time they cook chicken, must. You look at this story, you say, must. You know what deal. Give me the chicken and I don't tell money. You do it, but in much pain. Why? This person is under administration. So you should just abide by the whatever process. Okay? So now, when you look at administration, remember, it is basically an agreement. You can vary the agreement at any time. Then you have to look at variation of the administration deed under 167. Okay. Then you also have to look at further duties of the administrator like calling for the creditors meeting during administration. You agree on who should be paid first and who should wait. State an offense of being broke. Then you look at termination. Okay? You look at termination. When you look at 168, it says that administration shall be terminated where? One, the court makes an order under 168, then the circumstances specified in the deed occur. Now, what they always do, they can attach an administration deed. They put a termination clause down. So because you're seeing that the deed is huge, you will not waste your time reading. When the question was termination, and you draft a petition. Okay, so we have termination as per the administration deed, and then we have termination by court. So ask yourself, under what circumstances can we terminate administration by court? You go to 169, okay? Subsection 3 says that a court may make an order to terminate if the following circumstances happen. One, that the provisional administrator or the creditors were given information about the company business, property affairs, or financial circumstances that was false. Why are they using a provisional administrator? Because a provisional administrator, one of his duties is to make research about the company affairs, and then he makes a report and the proposal to call for the creditors. So the creditors agree to the administration basing on the report made by them. That's why in most cases they can't proceed with you. They drop you in that very meeting because you are likely to be a hypocrite. Okay, you made the research. You know where these guys can get money. Even you know whether they may or they may not survive. So as a result of that, we don't waste time. So where we realize that you misled us, the creditors, we cancel administration, we take you back to liquidation, and we see who is who. Okay. Then another one, that the report or statement under section 47 contained false. That's the report made by the provisional administrator after making. It also contains falsehood. Okay. Then C, the person bound by the administration deed has failed to comply with the deed, with his or her obligation. Now the question I'm telling you was under C. Remember, Miss Quata and Paula, the persons who are bound by the deed were doing the contract. So when you look at, after reading all those, then you come back to 169 subsection 1. An application for termination of administration may be made by 1, an administrator, the creditor of the company, or a liquidator. So what does that mean? The answer to that question was an application for termination by Quata and Bola, because he falls under the categories of people who can bring the application. So the question is, how do you bring the application for termination? So don't risk thinking only on how to bring the petition. What if it does not come? What if it does not come? Will you die? Yes? So don't risk. when you look at rule regulation, Regulation 161 talks about application to court to remove a provisional administrator or administrator from office. Okay, Rule 161. Okay, it is Regulation 161, application to court to remove the provisional administrator or administrator from office. Okay. So let's see how we make the application. It says an application under Section 174 of the Act to remove a provisional administrator or an administrator from office shall be made by notes of motion. So that means that application is by notes of motion supported by an affidavit. Okay. So now we presume that this person has been removed from office. So that marks the end of administration. So if it is not administration, do we have any other remedy that we can base on before our company is being subjected to insolvency proceedings? Yes. Do you have any other under the Insolvency Act? Yes. Or we are not sure. Customers. Okay. So now, we have in the Insolvency Act, we have provisional administration, we have the interim protective order, and then administration. There are only the 3 remedies. So the rest are found in the Companies. So now let's cross to the Companies Act. Yes. So now let's come to the Companies Act, the Bible, corporate and commercial. Now, we have the following. We have compromise. We have compromise. We have arrangement. We are going to read the section. I'm just listing it. But you look at section 234. Okay. We have compromise. We have arrangement. We have reconstruction. And then amalgamation. Those are under the Companies Act. So let's go there. Let's go there. Okay. So it says 234, arrangement and reconstructions. Arrangements and reconstructions. Okay. So that act was not, that section was not amended. Yeah? Don't get scared. Okay. It says 234. It says, where a compromise or arrangement is proposed between the company and its creditors, or any class of them, or between the company and its members, or any class of them, the court may, on application of the company or any creditor or member of the company, or where the case of a company being wound up of a liquidator, order a meeting for the creditors or class of creditors of the members of the company or class of members, whatever the case may be. What does this mean? We have two things. When you look at them, it may be hard to understand the difference in these things: arrangement, compromise, reconstruction. Okay? On the face of it, they look the same. What do you understand by compromise? We compromise with members of the company. That's why the section says that where a compromise or arrangement is proposed between the company creditors or any class of them, or between the company members. So what does this mean? Compromise is within, then arrangement is outside. Okay? When we were young, African mothers are good at compromise. Where visitors come, okay? Through African homes, every Sunday they eat meat, okay? Leave alone this generation where you buy your chicken tonight every day. But you're well off, okay? So what happens every Sunday? They used to cook meat, rice, matoke, sometimes chicken. So we have these visitors who come without notice. After church, they come following Mzee. When they reach home, and the Baganda say that when you enter the house, you can't live without eating. Okay? So now, Mzee can't tell them go. They converse, they give them water. Mama is waiting for these guys to go. They are not leaving. So at the end of the day, Mzee is very hungry. And then he's like, Mama Aisha, is there anything to eat? Then Mama Aisha is like, oh, these visitors. Now what mom does, they have to give the visitors first, okay? But she will call you, the children, okay? Aisha, come here with your siblings. Go and sit behind the kitchen. Don't come out, okay? If not, Aisha, get this 2K, go and buy tomatoes, okay? And give nuts. You cook some soup for your siblings. But don't come this side while you have again. So you see, it is a compromise. You guys are saying it's okay, but you saw chicken. You know the pain you go through when you're taking this plate to the visitor. And when you reach there, the visitor looks outside as if they don't want to eat. But after giving them the food, you pick empty plates without even leaving a bone. Okay? So now, what mom does is what we call compromise. You compromise the internal people so that the outsiders, they get what they want. After going, first we shall set ourselves. Okay? Then after visitors, they go to start. Then mom is like, I saw you, Aisha. You didn't want to take that food to the visitors. One did then all up. You get it? She also knows that you felt something bad, yeah? But because that was the only way to survive the visitors, she had no option. So she had to compromise with you so that you people first wait. So the same thing here in company, where we have creditors that are overpressing the company, the directors can call you, the shareholders and members. They say, you people, the fact is we are supposed to declare dividends at the end of the month. So I want us to agree. We have a lot of creditors. Please give us a period of 6 months when you guys are not getting the dividends. so that we reduce on our. So they have compromised within so that they save money to reduce on the pressure from creditors. So that's what we call compromise. But the section has compromise, it says compromise or arrangements. Okay. So now, if it's not a compromise, it will be an arrangement. Then we go for arrangement. So arrangement is made basically with the creditors. Okay. Now you get it now. So what happens here? You first make a proposal, okay, to the creditors. Once you make the proposal, you pass a resolution, okay. Because the section says that where a compromise or an arrangement is proposed, what does this? The word proposed implies that you should have a proposal for the compromise or a proposal for arrangement. So it's the first thing you do, okay. Then the court may, on application of the company or a creditor or a member, in the case of the creditors or of the members of the company, as the case may be, summon. So what does this mean? Once you make this, the proposal, okay, you make an application to court. Then the court will summon what we call the creditors meeting or the members meeting. Then you convene what we call the creditors meeting or the members meeting, whatever the case may be. It is once it's a compromise, we go for the members meeting. If it is a arrangement, we go for the creditors, whatever the case may be. Okay. So now, after all this, ask yourself, okay, under this, what things do we need to understand when we call for this meeting? Then you go to section 234. It says information as to compromise with creditors and members. Where a meeting of creditors or a class of creditors or of members or any class is summoned under 234, there shall, so you see the procedure now after, okay? Because now you have the summons. So once the meeting is summoned, all whatever is under this section, they should come in that meeting when they know it. So that means the notice calling for that meeting should include whatever is mentioned under section 235. For example, it says A, with every notice summoned for the meeting which is sent to the creditor or members, be sent also a statement explaining the effect of the compromise or arrangement. So you tell them that if we go for arrangement or this will be the outcome, okay? So as you proceed, they keep on telling you what should be there, okay? So do you differentiate between, you see, we have arrangement under the Insolvency Act and arrangement under the companies, but they are different. Arrangement under the Insolvency Act is for an individual. We don't have arrangement of a company under the insolvency. The arrangement is under the companies. So take your time and read section 234 at your own pace. Okay, are we together? So the arrangement of a company is under 234. So now you differentiate between compromise and arrangement. Is it okay, Kaz? Yes? We've said compromise is between the company and its members. Okay? A compromise with you, can you compromise with a credit? Because compromise, you have to forego something. Is there a credit who can forego money? But the members can forego dividends. That's why I use the example of home. Can visitors forego food when you bring it? They look the other side as if they don't want it at the end of the day. Aha, ole moi. Okay, you get it. But you, the children, Can you tell your mom, whether you like it or not, we shall eat meat. Let the visitors go. So it is easy to compromise with the internal people. Then arrangement is with the external. So arrangement applies to creditors, where you call them, you tell them, you know what? We intend to get some money. But as a result of that, this is the way we shall be paying you. Okay? We shall first pay this, then this, then this, then this. Can you be patient with us? Okay? You make an arrangement on how to pay the creditors. That's why it's called arrangement. Okay? So, how many remedies you have so far? The interim protective order, provision administration, compromise, and now arrangement. Then let's go to reconstruction. Let's go to now reconstruction. Sometimes it moves with amalgamation. They are provided for under Section 236 of the Companies Act. That's why it says provisions for facilitating reconstruction and amalgamation. It says where an application is made to court under Section 234 for sanctioning of a compromise or arrangement proposed between the company and the persons mentioned in that section, and it is shown that to court that the compromise or arrangement has been proposed for purposes of or in connection with the scheme for the reconstruction of any company or amalgamation of any two or more companies. So now, what they call amalgamation, there should be a wealthy company somewhere willing to take over this company that is suffering with all its problems. Now, what you people didn't understand, you heard of Embaga Airtel and Warid. Was it Zain and Warid by then? Okay? That was amalgamation. But on the face of it, the reason why we have amalgamation, the public can't know unless you are a landy person. That's one of the companies is facing financial. So one of the companies should be going through what we call insolvency situations. Then this other company says, those are small things I can handle. Please come to me. Okay? You get it? So that means this company that is willing to amalgamate with this one should be able to take on this company with all its problems. So that means this company that is taking over should be able to pay the creditors and settle all the debts. Okay? It's like you falling in love with a woman with kids. You agree. You take her the way she is. You either love her kids or it's a no. You get it? So that's what. So that means once you marry this woman, you have decided to amalgamate with her problems. So now fees should come in the same line. Okay? So you start paying fees even before you give back. So you see, it's the same thing. Once we do the amalgamation, you start paying wages to all the employees even before the company has started earning. Okay? That's the worst part of amalgamation. So for us, here, we will never know that Zain had problems because Warid was better off than Zain. So Warid decided to amalgamate. That's why once we did the amalgamation, everything's, that's why you saw Zain disappeared. They said all those guys with Zain SIM cards, you can buy airtime of Warid. Slowly, because they are still settling the creditors. Now, after settling the creditors, they made it one company which is currently known as Airtel. But it was an amalgamation. Then you have another amalgamation that we didn't see. You know, Ketu Telecom. Yes, that one for Kavaka. Do you still see it? But do you know that all the SIM cards of Airtel current now are K2 lines? So it was an amalgamation as well. They started slowly that if you have that 3 calls of Airtel, call to K2. Then after, if you don't have airtime for K2, you can buy of Airtel, it works. Then after, everyone with a number of 074, at first before, after the total amalgamation, once you call, it says, Awangale Aisava Sajja. Automatically. But now after the total amalgamation, it went back to Airtel caller teams. You get it? So it takes time. So one of the company should be badly off, then another one is well off. That's what we call amalgamation. Okay? Then, so now you differentiate between arrangement, amalgamation, and now we have reconstruction. What amounts to reconstruction? Reconstruction. What do you understand by reconstruction? They will give you facts where the company has a lot of employees. Okay? When the company is overspending on different things that are useless. Okay? The company has numerous branches. When it has a lot of creditors. So what the company does is does not close, but they do what we call reconstruction. They reconstruct their company. They say, we are having, you remember what in employment, section 188 of the Employment Act. What's there? Section 88 of the Employment Act. What is there? Collective. One of the factors of collective termination, we have what we call economic factors and then infrastructure. So where the company is facing a number of debts, it can go for what we call reconstruction. How they can say, we are changing employees from monthly to daily. Okay? Why? If I have 10 employees and I pay them 300 each on a monthly basis, that's a lot of money. But if I say we are going to change, we are going to work in shifts, okay? So this implies that 15 will work day shift and 15 will work the night shift. And I'm paying per appearance, I'm paying 10K. If not, we shall say the first 15 are working from Monday to this day. Then you get it. That means that the 300,000 is going to be paying to employees. You get it now? Because we are working in shifts. You work from Monday to Thursday. That means on a weekly basis, how much am I giving you? If the month has 30 days, I divide it into 2. Some employees work for 15 and others 4, and I pay per day. That means I'm paying her 150 and I'm paying her 100. But initially, I was paying both of them 600,000. I have reconstructed my company somehow, somewhere. Okay? If not, we shall do what we call laying off. We lay off some employees in the bunch. Some companies have what we call ghost workers. Because I am in charge, she's my wife, then I call her. Bring all your sisters. Okay? They don't have a formal contract, but because now, if I don't employ best sisters, they will go. Okay? So they are there. I give them command because Muna, I have to make them happy. So once we come, we say all of you without formal written contracts disappear. That means I'm also disappearing from home. Because after you see, we are reducing on the expense. That's why those who are working in government now, they are doing, how do they call that process? Okay. Verification. Okay. Currently, every government entity, they say, bring your ID, bring the appointment letter, and put them here. Most of them don't have IDs. That's the first sign that you are. Others have IDs, but without appointment letters. So you saw problems. People were not verified, so they couldn't pass the test. Okay. So as a result of that, we agree. If not, when you have a lot of branches, why don't you close some branches? Yeah? Because every branch needs to pay rent, not so. So as a result of that, you leave some of the branches, then you go for what we call reconstruction.
So in simple terms, what is it?
Yes. Okay. So are we together now? So you see that all those ways they can help the company save so that it pays its creditors. That's why before the company can be subjected to insolvency proceedings, we should take all. You see that those of the company are very many compared to those of an individual, because the company employs a lot of people, a company pays taxes. Okay, the government earns more from a company than an individual. That's why the law created a lot of avenues to save. So we call those what we call corporate rescue mechanisms. Okay, they are called corporate rescue mechanisms. Why? They rescue a corporate entity. So are we together now? So what happens if all we've mentioned refuses? Then we shall go for what we call liquidation at the end of the okay. Then we go for liquidation. Then we go back from where we started from section 57. Very simple like that. Okay, no. Now we go back to the Insolvency Act. Okay. So I tell you, corporate is simple, eh? But you just don't. You just set corporate, yeah. Eh? You just set corporate. So when you go to 57, it provides for what we call modes of liquidation. So according to the set of facts you have, they will determine the mode you are taking. So don't rush to make that decision. Okay. First read the facts and understand them. 57, okay, of the Insolvency Act. So we have by court, voluntary or subject to supervision. So the law is very clear on the different modes. So let's start with voluntary liquidation. So what is in section 247 of the Companies Act? 247. So I want you to read. 247 says alternative remedy to winding up. Read the starting point of that provision.
Section 1.
A
member of a company.
Stop there. A member of. Have you ever heard of what we call the members' petition for winding up? Yes. So that means if members don't deem winding up their company necessary, they can proceed under 247. But if they deem winding up their company is necessary, then we shall come and go for what we call. So now let's look at voluntary liquidation. It says, section 58, a company may be liquidated voluntarily if the company resolves by special resolution that it cannot, by reason of its liabilities, continue its business and that it is advisable to liquidate. Now, when you look at that by reason of its liabilities cannot continue business, okay? Show me the workshop. Show me the workshop. Okay? You have something on your workshop, okay? Which is there is what we call there's something I said I wanted you to deal with that is on task 1. There's something on task 1 that introduction, investigate, and the meaning and difference of cash flow insolvency and balance sheet insolvency. What do you think that means? You just Google what we call cash flow insolvency and balance sheet insolvency. That deals with assets and liabilities. That was in accounting classes that I never liked at LDC. I used to put headsets in that class, but the I entered that paper, I regretted why I used to put headsets, because I could count things I don't understand, and I cried in that paper. Cash flow. What is the meaning of cash flow? Cash flow is a comparison of what? Of cash at hand and
Cash at hand.
okay. It says there are a couple of key differences between the pair. Balance sheet insolvency compare assets and liabilities. Okay, so that means, remember, what are the components of a balance sheet? It has assets and liabilities. So that means once one of the factors you base on to make what we call the assessment of the factors, okay? You first look at your balance sheet. How many assets do you have? If your assets override the liabilities, that means you are not subjected to insolvency proceedings. You are able to pay your debts. But where the liabilities override the assets, automatically you are supposed to be subjected to insolvency proceedings. That means you are unable to pay debts in the meaning of section 3. Then cash flow insolvency compares available cash flow to meet outgoing on time. What does this mean? They compare cash at hand and cash at bank, as well as the liabilities that require this cash. Okay? So that means the money you have and the things that intend to take it, which outweighs the other. Okay? One of the sheikhs, when he was teaching us about polygamy, he said that now you, the youth, if you want to date more than 2 girls or 3, assume you have your car 200K. You receive a message from all of the 4 as you're dating them, requesting for 100K. What will you do? Okay, so because you may want to please everyone, you will divide the car 200, so that you give everyone like 50K. How are you standing? You see that you are remaining with nothing. Okay, what will you eat for lunch? At the end of the day, you will go for Chikomando, and that Chikomando will just borrow it to you. What does that mean? Your cash at hand is less than the liabilities that needed to flow. Okay, because those 4 ladies you have, what makes their blood move? Seeing the message you have received. And for you to receive that message you have received, you need the intervention of the Holy Spirit. That's hard work. You get it? So when it comes to this cash flow insolvency, we look at the cash you have and the things that need this cash. what overrides the other. Okay. Then balance sheet, we look at assets and liabilities. Simple as that. So when you look at this, okay, they are saying that a company may be liquidated voluntarily if the company resolves by special resolution that it cannot by reason of its liabilities. So for you to say that you have a lot of liabilities, you should have looked at what we call balance sheet insolvency or cash flow insolvency. You get it? Those will be taught by Kaso Ambuga. I tell you this, go and look at that class. It's the only person I'm sure about insolvency. Okay? Then, so when you read this provision, how do we commence? What is the starting point for voluntary liquidation? Yes? What is the first step? Because you always do what we call the procedure for liquidation also. What is the procedure? Yes? You read it, the company may be liquidated voluntarily if the company resolves by special resolutions. When you look at this, which resolution are they referring to? A special resolution. Now, this special resolution, is it of the board or shareholders? They're talking about a shareholders meeting. So that means the first thing you need is to call for the shareholders meeting. So you issue a notice, then after you convene the meeting, then you pass a special resolution, you register it. The day you pass the special resolution, that is when insolvency commences. Okay? The day you pass the resolution, as per section 58, subsection 2, it says voluntary liquidation shall be taken to commence at the time of passing the resolution. So once you pass the resolution like this, and you continue transacting with the company assets, then that transaction is known as void transactions. So make sure, because your workshop may not be able to deal with everything, but read, you don't leave the gap in insolvency. Okay? I pray it becomes your paper, because the last appeared when? Was it 2020, 2021? And it came as an emergency paper. Yes? It was a bit funny. Last year they did banking basically. Okay, it had some little bit, but it wasn't straightforward on that. But 2021, 2020, it was the emergency paper they did. But it was fire in the city. No. Eh? So we together then. Okay? So now, they're saying in this part, resolution for voluntary liquidation means a resolution passed under subsection 1. So now, after you've passed the resolution, the presumption is liquidation has commenced. Then after commencing the same, you proceed under 59, you give notice of voluntary. Okay, you give the notice. So this notice should be given to so where the company passes a resolution for voluntary liquidation, it shall within 14 days after passing the resolution, give the notice in Gazette. Why do we do that in the Gazette? We notify the entire public that please don't deal with Mercy. She has no capacity to contract